Says on the schedule, which might have been a typo, 2:20, 2:45, but we're going to start now. Comments from the general membership and the general public. So is there anybody from the general membership and the general public who would like to share with us now their thoughts, feelings, and concerns about the bar structure of the Washington State Bar Association? Nancy Hawkins, please come forward and share.
Before the break, somebody made the comment that there wasn't a groundswell of sections asking to be relieved of their role within the Bar Association. And I think that that absolutely needs to be a focus. Nor do I think there is a groundswell of sections wanting a safe harbor. And I totally understand the outrage of about things that are going on around the country as a gay person myself. And I totally understand that section wanting to make all sorts of comments, because I do too. But I recognize that this isn't the organization for those comments. And nor should we be restructuring so that lawyers can make those comments as if that's the only way that they can make those comments. I don't want us to think that, because again, sections are not asking for this, whatever you call it, bifurcation or freedom or whatever. We're not asking for that within this context. Being a separate, to be a separate organization would, under the ways people have been commenting, is either each section somehow forms its own entity, which would mean that they would all die, because even a section with 1,000 members, so like solo or family law or RPPT, that's not enough money to have staff, to have space, to have stuff. It's just not enough unless it's hundreds of dollars per person. We're not asking for permission to make political statements. We don't need a political arm. We are asking as part of our, so first of all, what, 95% of our work has nothing to do with the legislature. So for some of the sections, it's 100%. So for the part of our program that deals with comments on legislation, it is not to be political. It is not to endorse candidates. It is not to speak in favor of candidates. It's not to run publications in favor of candidates. It's to make comments about legislation that is being proposed in our very state. And any piece of legislation should fall within an acceptable area for comment by the relevant section that may want to comment. So if every section would have to be its own entity, there would be no sections, because financially they could not survive. So then we look at, okay, some people say the sections as a whole should go off and form their own organization or be given one, and the rest of the organization leaves. But either way, so does that mean that we're going to all agree? Does that mean that this organization of, let's say, 10 sections are off on their own as a group. Does family law have to then go through some legislative committee of those 10 sections to make a comment? How's that any better than where we're at now? Or do we get to do what we want? Well, then does that then piss off, the corporate section or the criminal law section? And then they're mad and then they want to leave, or we want to leave, or whatever. It doesn't solve a problem. There's still disagreements. There still needs to be some sort of structure that says if there's a piece of legislation, people can make comments within their lane. During the break, I had a discussion about an issue that came up this year where there were different points of view by two different sections. This two sections met. They worked out a deal. It got presented to the legislature. Everybody's happy. That's the beauty of coordination and discussion, and everybody accepting that that everyone is trying their best. There was a comment earlier about 90% of the members not being involved. Well, it's higher than that aren't involved, but it's not that they're not involved because family law or somebody else made a political statement that they disagreed with. Because, as I've said before, for decades, I was one of those lawyers too. And it wasn't because the Bar Association did something that made me mad. I had no idea what the Bar Association was doing and didn't care. I read the Bar News or whatever it was called back then to see who got disbarred and if I knew them or if I was doing whatever it was that they got disbarred for. You read it to see who died or if what they said about someone you knew who died. That was the goal, reading the Bar News. Sorry, Sarah, I read it page to page now, cover to cover. But people don't get involved because they have families, they have kids, they have jobs, they have illnesses. Those are the reasons people don't get involved, not to mention what a glorious bunch of fun it is to be involved with the Bar Association and its annual problems that never seem to go away. They may change, but they never seem to go away. So we don't need to worry, I don't think, about there being 90 or 95% of the members that are not involved in the day-to-day business of the Bar Association. We should be thankful because God forbid 1,000 people would have showed up for this meeting and one by one got up and said, I wish my dues were less. So either they don't care because they're busy but more importantly, they trust whatever's happening is okay, or they would get involved. I think that freedom of association is great, but freedom of association is not absolute. We every day spend time with people that we disagree with. That's what you do when you have at least one shared goal or shared mission or are in the same place at the same time. If you take a train from here to Portland, you're associating with people. And associating with people you don't like or whose politics you don't agree with. It's not absolute. And this organization will, whether, let's assume, God forbid, all the sections are gone or somewhere else. You as a board of governors will still make decisions that some people will disagree with. Your abilities to get along with each other will not result in unanimous decisions on every issue. You just may not have sections or committees or boards or loud members coming to disagree with you. So again, the best approach is still to continue what we're doing tweak as we need to, but not try and second guess and assume that a different structure is better just because a few people might think that it is.
Thanks very much, Nancy Hawkins. Let's see, we've got Professor Straight, followed by Governor Stevens, followed by Governor Peterson, followed by Governor Couch.
Well, I want to second the comments that were just made, but I also want to throw a little bit of history that Doug didn't include on Rule 12. When we originally adopted that, as Doug was describing, in the hopes of avoiding a challenge, there was a significant debate as to whether or not the sections who are voluntary would be covered by the rule. And because particularly for the criminal law section, and I suspect for others, but especially us, the lead time for comment to have any influence on very bad or very good legislation that is being proposed in the legislature is so short, partly because of that hero bill problem I mentioned earlier. It is just not feasible to go through the Rule 12 process in order to comment as the crim law section. And I actually negotiated that compromise with the legislative committee back in shortly after the rule was adopted, so that this crim law section was allowed to take a position so long as it identified itself as not speaking for the Bar Association, but only for itself. And that was the process we followed for quite some time. I'm sure I don't have to remind the current members of the BOG that there was an effort to take much more close control of the sections that was quite controversial and resulted in a lot of agony and heartache on everybody's part. And it is my belief that the idea that the section should have no independent voice from the Bar Association itself was in part of that. And I think it's a big mistake. And I think it also generates some of the issues that you're hoping to resolve. So it seems to me the easiest way to resolve at least the Rule 12 issue is to stay where we are, but allow the sections to take positions so long as they distinguish themselves from the Bar Association itself. And I do appreciate the comments that were made earlier that it does, I think, have more influence if the WSBA takes a position than if an individual section does. I wouldn't disagree with that. But if the price is nobody takes a position, because by the time a position can be considered to be taken, it's target gone by, there's no help, and certainly not the kind that we all hope to have on making sure that legislation is of general value and not simply a hero bill, or in worst case, actually detrimental. So I want to second Nancy's comments about the fact that there's no screaming call for restructuring from us, and that I can speak for the sections on. We have had that discussion. And if anything, we have a concern about Rule 12 being interpreted too narrowly to apply to voluntary groups, like the sections. Thank you for the opportunity to speak.
Thank you, Professor. We're up to Governor Stevens.
I actually want to thank both Nancy and John for the comments that they just made. I just wanted to add, because this context of so many of our members aren't involved in WSBA and they don't care. And I think the better view is that they really hold us to be stewards. But I just wanted to talk about some of those other activities. Some of that is a part of my life long before I ever engaged with WSBA whatsoever. And that's activities with my my MBA organizations, other specialty bars, local bar associations, community, school, and church activities, civic and political organizations, all of the other things that people that our members do and bring value as lawyers to those various organizations that want to do that work. And we are short-sighted if we think the only way they can really be engaging is engaging with WSBA. Well, quite to the contrary, they are engaging in their communities. They are engaging on so many other levels, and not as concerned about some of the issues we have here. But this then becomes an issue when we're talking about engaging in WSBA activities. But please let us not take this notion that because those members are not directly involved with WSBA, that they don't care and aren't involved and engaged with the public and in championing justice. Thanks.
Thank you, Governor Stevens. We have Treasurer Governor Peterson.
Yeah, no, thank you, President Tolson. I agree with a lot of what Ms. Hawkins said. I mean, I think we just have to remember that we have a lot of good things that we do. I mean, I think our bar association is probably one of the better ones in the nation. And yeah, do we have problems? We do. Do we work on them? We do. But as far as the way I'm kind of looking at the current situation is, I'm not going to take something that I think is very good and change it unless somebody can convince me if there's something better. And and I think the burden is on those people that think there is something better to indicate what is better and how we get there. Otherwise, I'm just going to stick with the very good. Thank you.
Thank you, Treasurer Peterson. Governor Cash, followed by Governor Williams-Ruth.
You're muted, Governor.
Oh, there we go. Thank you. I thought it would take a minute, and if you'll indulge me, share some of the things the public thinks about this, some of which is very germane, some of which is ancillary to that. So I went to Google, which tells me what the public thinks about the Washington State Bar Association. And here's some of the things they say. I emailed them a question, never got an answer. Never did recommend any attorneys that would take my case. 2 stars. Very helpful and promptly returned my call in a timely manner. Thank you, Washington State Bar Association. I never liked lawyers until I called your office. 5 stars. I see the corruption within the government as a whole. However, there's still a lot of good people trying to make it right. Like Melissa, she helped me 3 years ago through the Northwest Justice Project, and honestly, she helped me more in 1 week than the attorney I spent $10,000 on in 9 months. Thank you so much, and even to this day, I think about how much you helped me and want to thank you from the depths of my heart. 5 stars. A complete joke. Corrupt attorneys supervising more corrupt attorneys. This agency should be turned over to the state. It is the only agency in the state that governs over professional licenses without state regulation. Not sure what he means by that. Rude, lazy, and incompetent would be a mild statement for this agency. The state needs to step in and regulate this agency. If you have issues with them, report them to the DOJ. 1 star. Can't stress enough the amount the Bar Association saved me from corrupt attorneys. Thank you. 5 stars. Washington State Bar Association is a toothless, weak organization that only tends to the needs of its members. Asking them to police their membership is tantamount to asking the fox to guard the henhouse. 1 star. Here's a 5-star review that says, WSBA is a mandatory bar association for lawyers in Washington. That's the entire review. The professional and regulatory bodies related to the practice of law need to be separate. 1 star. They gave me names. 2 stars. Will reevaluate when finished. 3 stars. Explained my dilemma and they're going to help. 4 stars. Great way to find the right lawyer near you, etc. 4 stars. So as you read through these, you will notice there are people who feel disheartened from complaints they filed that they didn't feel through proper follow through went through. And those are the people who tend to say this entity needs to be separated into a regulatory agency and everything else. I emphasize this only to say, to go back to what I'd said earlier, self-regulation is a privilege that we have. It is not a right. We are one of the few organizations in the world that does this. And I think we have to recognize that as we think about what value we get out of this, there's also value to the public that we can serve in this and do serve in this. And the public that wants us to be separate tends to be the public who wants to see the regulation that we are providing, or sees the regulation we are providing as a failure. And so the question to ask ourselves is, do we agree with the public in that our regulation is failing, or do we think we're doing really well at that? That's one thing that's relevant is it working in the system we have right now for the good comments, or do we agree more with the negative comments? Thank you.
Thank you, Governor Couch. Governor Williams-Ruth.
Thank you, Mr. President. So I just want to ask Professor Straight a question because of the fact that we've heard today already that section speech is bar speech. That is what our rules say. That's what the Fifth Circuit has said. So if, you know, so we can't have a situation where something is issued by the business law section that's not WSBA speech. And you may not know, but you're actually tangentially responsible for me being here because of my connection and friendship with Tara Simmons. And I have been fighting for change in character and fitness, change in our rules, so that way we can be living and doing what is right through an actual process. And I struggle every single time we are brought with something when we can't, because we've had that proposal. Well, let's just have this letter signed and say, let's have a disclaimer paragraph at the beginning. This letter is not coming from WSBA, it's only coming from the section. But that's not reality and it wouldn't hold up. So if the option is to not let them speak at all and not have any speech, or should we just continue to hold our nose, let stuff slide by and hope and pray that statute of limitations is going to pass before someone who actually isn't just shooting in the wind, but actually wants to come and attack the association with a valid claim? For example, shark fin legislation. I mean, that statute of limitations is still hanging out there. And someone could come and say, we went and engaged in this conversation. Do we not have a duty to actually abide by our own rules?
Anybody else have their hand up, want to comment? Well, Professor Straight, do you want to, do you have a response or a rebuttal?
No, I totally agree. We should abide by our own rules. I have questions which I don't share the prevailing view on, that the sections can't, as voluntary organizations, take independent positions as we did. I am not convinced that it's appropriate to say that because the sections get funding from the state or from the WSBA, that automatically makes them spokespersons for the WSBA and vice versa. And I think that's a position that I don't share. And that's all my comments were aimed at. I obviously share the concerns about the character and fitness process, but that's a topic for another time. I have very strong feelings about how that should be reformed, but that's not something I think we're here to discuss today.
So should we amend our bylaws and remove the part that says the sections are part of the WSBA?
I think so.
Okay.
I thought that was a mistake when it was done.
So any other comments, questions, or concerns? I thought right now that the Board of Governors had the power to, if they wanted to, make sure that they let a section speak on a particular piece of legislation or a particular, say, proposed court rule. They could say, yeah, you can go ahead and speak, but make it clear that when you deliver your message to whoever you're delivering your message to, you're speaking only on behalf of that section and not the entire Washington State Bar Association. And the example that I give is, and I can't remember which section it was, wanted to comment on proposed criminal rule 7.8, which I think is still pending. And they had, and the cover letter from our executive director points out it's only the position of that particular section and not the
I think the question, the prior clearance before that.
Right. Yeah, you have to get clearance, but still the board of governors could say, yeah, you're not speaking for us, you're just speaking for you.
And I think the board very likely should do that. I have no problem with that whatsoever. The point I was raising was one that's a more procedural problem, which is because of the pre-clearance requirement, it is practically impossible to speak on many of these topics in a timely manner, even though we have our supermajority of 12 out of 16 of our executives committee, which guarantees that there will be pretty much across the board agreement among prosecutors and defense counsel as represented. And so that's, as I said, I thought it was a mistake for the bar to declare the sections to be essentially the WSBA and to impose or try to impose a series of requirements that I think are appropriate for the WSBA itself. And I do think that's a modification that could be done. And I don't, as long as we don't, I don't believe as long as we don't claim that the sections are a speaking agent of the WSBA, that there's the same constitutional concerns.
And now I remember which one it was. It was the Council on Public Defense that wanted the AOK of the.
Yeah, and I've served on that, and the Council on Public Defense is, of course, not a section. It's a special, essentially, created by the court. And I serve on a number of other related bodies as well, including, as Alex was talking about, I know that an awful lot of lawyers who aren't active in the bar because they don't consider that to be their primary focus are very much involved in law reform efforts in other venues. It's not the only one. But the idea that my comments were intended to interpret as we shouldn't follow our own rules. No, I don't agree with that. I spent my life as a lawyer, now getting close to 50 years, trying to make sure that people do follow rules.
Thanks, Professor. Governor Stevens, followed by Director Platchey.
Well, I just wanted to also correct. So I believe, and I'm gonna look at, for example, immediate past President Cicchetti, but I do believe that especially during session, we have actually devised rules so that sections can go to the legislative committee. Doesn't have to come to the Board of Governors because the Board of Governors is meeting only intermittently. The legislative committee is meeting every week, and there's been a grant of authority to the legislative committee to act on behalf of the board to take that issue up in terms of a section being able to make comment either in writing, make comment at committee meetings and such, provided, of course, they have met the threshold, the GR12 threshold, and they've done that analysis and have gotten the supermajority. So, those things have been done. I'm just of the view or the concern that as we are looking at some of these other challenges, that we become hypersensitive to granting that authority, even if they've met the GR 12.2 analysis, and that is a very big concern, that we just say, well, we might get sued, so even if you've met that analysis, you can't speak. But that hasn't been where we have generally gone, as I recall.
Oh, Governor Stevens, there you are. Director Platchy's next, I think.
Yes, thank you, President Tollefson. I'd just like to make a comment because I think we had this discussion a couple meetings ago, and it was this idea that the sections are considered a voluntary organization and therefore shouldn't be considered, their speech shouldn't be considered WSBA speech. And I think and I know probably people are getting tired of hearing about the Fifth Circuit case because it doesn't apply to us, but in the Fifth Circuit case, the McDonald case, the State Bar of Texas specifically brought up as a defense or a defense argument that their sections are voluntary and therefore their speech should not be considered bar speech. And the Fifth Circuit unilaterally said, no, that is not the case because the sections, the governing body of the State Bar of Texas, like our Board of Governors, has discretion and authority to determine what they can say and can't say. So because of that, that was one of the rationales for why the sections wouldn't be considered separate in terms of their speech. And the other was that some funds from the State Bar of Texas, the mandatory dues, supported sections. Now, I think there's some argument to be made that sections are financially sort of independent through their per member charge. But the fact that the Board of Governors controls the ability for the sections to comment, I think is something that is very comparable to the Fifth Circuit case. I'm not saying that the Ninth Circuit may come down and say that. I think that's the interesting thing to see is how does Crow come out in the Ninth Circuit, because they're going to take up this very same issue of freedom of association. But I only bring that up and raise it because it was a specific argument, a defense argument made in that case, and it didn't carry with the Fifth Circuit for those reasons.
Can I ask just a quick follow-up to that? If I'm I think I'm missing some part of that though, because if I'm understanding that right, it sounds like if the Board of Governors took away their oversight over what sections said and could confirm that the sections were self-funded, we don't have a problem. But there's something else there too, I'm guessing. Sorry.
The only thing I'll say is the two things they brought up, and Julie's probably can jump in here. I mean, she's the legal expert on the case, but from what I read and understand and what we discussed is the two arguments were that the State Bar of Texas, the governing body of the State Bar of Texas, determined and set policy for what the sections could do. And that put them under the purview of the bar. And then there also, there were mandatory fees that were supporting in some way the sections, even though the sections did pay reimbursement back. So I think those were the two arguments. I don't know if you eliminated those two, I mean, that's getting beyond my scope of understanding. I was just bringing up the arguments because those arguments were made in the case and the Fifth Circuit they didn't carry with the Fifth Circuit.
Okay, just quickly, yeah, that is how I remember it, and I'd have to think back through the details of how they described their sections. I'm trying to remember if it's that case or another case. That there is also this concept of, so if you think logically through it, GR 12 applies to the WSBA, right? The Washington State Bar Association. That's what it says in the court rules. The bylaws say that the sections are part of WSBA. And in a way that makes complete sense to me, because if they're not, then what are they? And there's this sense in the decision about there just isn't any, like, what is the separate structure? How would you in fact describe the separate structure of sections if they weren't a part of the WSBA, and what, you know, what are their kind of rights and responsibilities? Then there is no, that's awkward for me to think through a little bit. And then the other concept that I think is in that case is it's a little bit hard to say that the Bar Association there and also here reviews the proposed comments that the sections want to make and, you know, says yes or no. And then you're like, oh yeah, but it's not really our speech. Yeah, we looked at it and we approved it, but it's not really our speech. And, you know, from the Bar Association's point of view. And you know, there's just a feeling kind of, I don't know that there's a separate finding. That the court's finding in the Fifth Circuit was just straight up that section speech is bar speech. But I think there is this idea that the rules that control it are the compelled fee rules. So the First Amendment rules. And that because the bar is reviewing it, it's just a little weird that the bar could say, well, yeah, we reviewed it and approved it, but it's not our speech.
Thanks for that. Okay, so I have 3 people in line here, and I want to make sure everybody wants to share that's got their hands up. Don't put your hands down. We have President-elect Clark, and I think he's got a chat. Read the chat, right? Is it to Julie? It's a question to Julie from President-elect Clark. Oh, I can read it. Question for Julie to follow up on a previous comment from Professor Straight. I've spent 5 years on the Board of Governors and Legislative Committee. It seems like we used to require that the sections typically give a disclaimer that they were commenting or speaking to the legislature only on behalf of the section and not Washington State Bar Association. We changed that a few years ago with the new legislative policy, as I thought that there was a desire that if we had 2 sections, one testifying for and against, that caused confusion with the legislature, and that legislators think a section is official Washington State Bar Association speaking agents. So then it became they're part of the Washington State Bar Association. So when they speak with the weight of the Washington State Bar Association as an organization behind them. If we can go back to the old way where they clearly disclaim that they're only speaking for the section only and not the Washington State Bar Association as an entire organization, would that help protect the Washington State Bar Association from First Amendment freedom of speech and association claims? Hope I read that correctly.
Okay, that's a long question. And I'm not sure I can answer it off the top of my head. I would really need to think it through. But the things I would look at is, number one, is the speech actually separate? You know, can we defend the idea that sections are, I guess, separate voluntary entities that have a separate ability to speak? And I think you should, I mean, yeah, I think the answer is likely no. And I think that's what the Fifth Circuit found. But, you know, maybe you need to talk through that more and let, you know, if that's an issue where there's disagreement, which, you know, Professor Straight clearly disagrees, maybe there's a need to discuss that and really, you know, talk about it and come to some agreement. And I think the other area that personally I have a little bit of a hard time understanding how you would just kind of think through an argument is this idea that the legislative committee is reviewing the section's comments, and the bylaws say that the legislative committee has the authority to approve comments for the bog. I think those are the words. Once you're looking at the speech, then it's hard to say that it's not your speech. Like, what are you doing if you're looking at it and it's not your speech? And yes, I think that before there was this idea that it was only the sections, or the disclaimer that it was only speaking on behalf of sections. And I don't honestly recall, but my understanding was that, that just seems to be not necessarily a logical conclusion. And I do think this idea that, is it really true that the legislature would be confused if the Washington State Bar Association were to send comments that included two separate concerns or ideas or thoughts from two sections that were different? And, I would have to defer to Sanjay on that, because I don't really know, but I don't understand why that's necessarily true. If why would we, it seems to me that it's possible, especially if the concerns are not about the same sentence or whatever in the legislation. But I think that's all WSBA speech. So President-elect Clark, I believe that, at least off the top of my head, my answer is probably not, because I'm not exactly sure at this very moment as I sit here how we would defend that answer.
Faye, I hope you all heard me because I had my mic off.
Thank you. I just jumping in the middle of the line here for a minute, but just to comment a little bit on what General Counsel Shanklin said, and the comment from President-elect Clark. My recollection as the chair of the Legislative Bog Committee for 2 years during that time, where Governor Higginson and I were working on the draft policy, you're correct that in the past we did say occasionally for people, and prior to my being a chair, that you could go to the legislature and say that you're not speaking on behalf of the WSBA, you're doing it on behalf of the section, because that was the easy way out. I think they thought if we just said that, everything would be fine. But then when you look at it a little bit harder and closer, then the sections aren't a separate entity. They're not a corporation. They're not a LLC. They're not a separate body. They are within the WSBA. And so then the focus started to be, well, how do you distance ourselves from the section? We certainly, if the sections had volunteers who were sued, well, I would think that they would be defended under the indemnity provisions of our bylaws as volunteers. But then how would you then say then they're not really a part of the WSBA on one hand, but a part of the WSBA on the other? It just didn't make any logical sense to us. So then the part of the policy that we put together was to try to shore that up, not say that you can just go and say that you're not a part of the WSBA, because in our feeling that they generally were, and address it through being able to come to either the committee or the legislative affairs manager for at least review. And you could call it permission, I suppose, but just making sure that we weren't violating GR 12.2 as an organization. So I think that's how it worked out. The reason we did it in the first place and prior to my involvement, I think, was just because it was an easy thing to do and we didn't really look at it that hard.
Okay. I think we're up to Professor Straight, followed by Governor-elect Fay, and then we've got some other people in the queue. Governor Stevens, followed by Governor Higginson.
I think, now speaking in my formal capacity as a constitutional law professor and litigator, that there are major differences if we make them. And I thought that's what this discussion was about, was whether Plan B, if needed, would be in place. Seems to me that Plan B for the section speech is very straightforward. Do away with Rule 12. Don't require a screening. If I completely agree with Julie that if we are reviewing what the sections say to the legislative body and essentially saying, yeah, thumbs up, thumbs down, that makes it the WSBA speech, even if it's labeled as the sections. And I think that was a mistake. And I think also labeling the sections as elements of the bar, as opposed to supported independent entities for the purposes of some of their functions, and in particular speech, that's one of the things you carve out. You don't try to regulate the section's ability to speak. You only require them to identify themselves properly. And beyond that, they're on their own. Given the political tenor of the times, there are certainly going to be in the bar libertarian values, some of which I might even share, but not particularly these, that don't want any regulation of any kind. I obviously don't agree with that. And so trying to make all of our membership happy by asserting control over the sections, I think is frankly not likely to benefit us in the long run. And it actually makes us vulnerable. Two elements of the Texas case, the Fifth Circuit case, are number one, that the bar was taking control over what the section spoke. And number two, they were labeled as parts of the Bar Association. Those are not written in stone. In fact, I think those are largely the product of the last time we did a bylaws adjustment or rewrite. And I think that's two of the things that I would recommend change. And then with regard to Julie's comments about how you defend it on the basis of free speech as well as association. You defend it on the premise that the sections have an independent right to speak.
Thanks, Professor. Governor-elect Kevin Fay.
Thank you. I happen to have the McDonald decision, the Fifth Circuit decision up on my screen right now. And the voluntary sections as distinguished write and lobby for bills in Texas. But the bar, using mandatory dues, supports those efforts. And here's their laundry list. The legislative program must be approved by the bar's board, placing the entire bar's imprimatur on it. Secondly, the voluntary sections are funded in part by the general fund. And third, the bar funds a government relations department, which manages and coordinates the state bar's legislative program. That's a three-legged stool. And nowhere in the McDonald decision do they even talk about whether the sections are part of the bar or not, or how the sections categorize their legislative activity. The three, pre-approval by the board. We have the ability to do away with that. There are bylaws subject to the Supreme Court. The funding of the sections includes section funding in part of the Keller deduction. Three, they have a government relations department which manages and coordinates. We can still have a legislative section as long as they don't manage the other section's legislative activity. We can very easily fit the Fifth Circuit test, assuming that it would ever apply to us, which it doesn't. So I don't see the Fifth Circuit decision being all that much of a problem. I agree with Professor Straight on that.
Thanks, Governor-elect Fay. Governor Stevens, followed by Governor Higginson.
So I am, this is a curious question because actually this session, and I believe Ms. Hawkins may be able to shed some light on this, but there were two sections who had what appeared to be conflicting interests. Let me just put it like that. But we had within our processes that our legislative manager, Sanjay, was able to bring them together and also bring together the issues to the legislative committee for the committee to work with and encourage the sections to do the very best they could to harmonize or at least not be in just total conflict with each other. And that worked out. And I was very pleased to see that worked out because I think it is a error to say that a section cannot state we are speaking as the section of the Washington State Bar Association and not of the entire Washington State Bar Association. But this then poses this other crazy question, which is, so we have to be monolithic. And we have to somehow or another determine that everybody else is in agreement. So even if you didn't have two different sections being asked to comment, if one section wanted to comment, we'd have to do what to ensure that everybody agreed? Now I'm just thinking about how that actually works in reality. I mean, we're lawyers. Everybody agreeing is a fairy tale. The question is, how do you make and distinguish what your position is versus another position? Two different sections, they may be looking at the same legislation and raising issues and questions and concerns out of their discipline. And that is for the legislature and the legislative body to have access to that information so that they're not just heading down one path and not considering unintended consequences. In the end, like I said, and I think Ms. Hawkins actually mentioned this, both sections were able to work out a way in which they could present their positions and not attack each other and actually provide, I think, important information to the legislative committee regarding their perspectives on the legislation. Otherwise, to me, a more tragic result is that neither could say anything, period, because they had two different points of view about the legislation given their disciplines. We have 26 sections. There is a reason for that. And the reason for that is we're not all just monolithic and just working on these issues under the umbrella of law, as opposed to legal analysis based on our disciplines. And like I said, I think that was handled, and I think it was handled appropriately.
Thanks, Governor Stevens. Governor Higginson.
Thank you, Mr. President. Some of you may remember some discussion, I believe it was at the Legislative Committee, possibly at one of the Board of Governors meetings over the last few years, in which the history of what happened with a couple of sections taking opposite positions before the House, I believe it was the House Judiciary Committee, or whatever it's currently called. And it caused the chair at that time to pull aside our lobbyist and tell him, if the WSBA wants any bills coming out of the legislature from now on, you need to, we're killing everything unless you guys get it together and figure it out. And that is what caused a halt to be called to sections commenting at all, according to what I was told by our lobbyist. And after that, with sections being understandably rather upset that they couldn't make comments to the legislature, Kyle and I ultimately on behalf of the legislative committee, worked on a sections legislative policy, which went through myriad iterations, and it's not perfect, but it was designed to avoid the problem that led to the lobbyist being pulled aside and being told what he was told. I know that's been a great frustration to some of the sections, and it certainly does bear some updating perhaps, but that's what happened. So when I hear from people, just let the sections talk about whatever they want, and they can just distance themselves from the WSBA by saying, no, we're not talking on behalf of the WSBA. I am just here to tell you that according to what I was given to understand, that isn't how the legislature viewed it, at least as of that period of time a few years ago. The legislators are busy, and they see WSBA, the elder law section WSBA or whatever section it is, and they just see WSBA, and they assume that the section is speaking on behalf of the WSBA. And when there's two sections that have a different view, as does occasionally happen, including the most recent example, they don't know who to believe or who to listen to, which is why I thought the more recent situation, since I'm on the legislative committee too and have been for 4 years, worked out really well, where the sections were able to meet together with Sanjay and as I understand it, and worked out some language as a compromise position. So then there was a united position to present to the legislature on the issue. And that's perfect. And it won't always happen, it's true. I mean, not everybody is going to agree. But I do think that it's important for us to think through, and getting back to Dan Clark's question, that if we say sections are able to speak as they independently wish, one, they're going to be perceived as looking like they're talking on behalf of the WSBA, whether they say they're not, or whether they don't. And number two, it seems to me that there's an argument that could be made by one of our members that says if they're perceived to be speaking on behalf of the WSBA and they are supported by my member dues, since everybody recalls, the sections charge their dues and a portion of that is charged back to by the WSBA to cover the overhead of us supporting them, still think we're in trouble. So my analysis would be, we have a First Amendment issue if sections are allowed to speak willy-nilly without having to work this through appropriately to protect the organization. I myself think sections ought to be able to talk as they want, but if they're going to do that, they need to become a different type of entity so that they can. So I'm completely in favor of a section taking a position. I think it's a really good idea. I just don't think that may be a good model when we're looking at First Amendment issues. That's all I have to say.
Governor Stevenson, you got your hand up again.
Yes, I do. And but this is only for down the road because we talk about the First Amendment. So what portions of the First Amendment are we talking about? Does the association part of the First Amendment trump speech itself? I mean, so as we talk about it, even when we're talking about First Amendment, I'm thinking, because I have a problem with compelled association, I can tell you to shut up. I can tell you to say nothing. I can tell you to stand down and not assert your right to speak. That's an interesting place.
Interesting indeed. Any other comments, thoughts, questions?
Well, Mr. President,
Mr. Stevens.
Because I do think Governor Higginson is right, and maybe we can get a little bit more information, because actually I do believe that the issue that came up this time worked as it was intended, and that was having our legislative affairs manager bring the two sections together to do their work, to do everything possible so that they could both provide their information without being in such conflict. And I think that did work and worked out well. And that's then the idea of balancing and working those issues so that it is not confusing in terms of who's providing what information. And like I said, I think that had a lot to do with what perspectives of the law was being provided by Section A versus Section B. And actually in the legislative process, I think the legislators needed to have that information from both of those perspectives to make the best law that they could.
Okay, yeah, and I think Nancy Hawkins got some more information about that she'd like to share. Because she and I were talking about it at the break, and I had a different understanding of how this thing all came together than she and I had different remembrances.
Thank you, Clay. Sorry. The incident with the chair of judiciary, I think it was, or law and justice, again, I don't remember, they've changed their name a couple times, but involved the family law section. If I remember correctly, it was involved the family law section and the estate planning people. And the definitely faced with a grouchy legislator who didn't like hearing two different opinions about the same bill from the Bar Association or from entities of the Bar Association. So instead of sort of chalking it up to a legislator having a bad day, it has become this much bigger event. But the truth of the matter is that pieces of legislation have different effects on different groups of people. And different sections have different perspectives on different parts of pieces of legislation that are sometimes pages and many pages long. And so a bill, for example, that provides for a great estate planning, save taxes solution to a perceived problem of what happens at death, has an unintended consequence on people at divorce and vice versa. We deal in situations, for example, we being family law lawyers, deal with situations where when people buy houses and one person's putting up all the money and one person's going to have it in their name because they're putting up, grandma's inheritance money. And then the bank insists that they have a deed that the spouse signs. Then 10 years later, when they're getting divorced, that wife is arguing that it's community property when their name was only on the deed because the bank insisted on it. And then we have these fights, and I guess I just heard that there's a new case that just came out this week. I haven't even read it yet on that topic. But the truth is that something gets done for one reason, but it has unintended consequences in other areas. That is a reason to keep sections so that you have all those perspectives. I'm sure if there had been 5 years ago, or whenever it was, more trust with the legislative staff at that time, which is not the current staff, that situation could have been handled differently, could have been handled better, but it wasn't. And the situation this year was one between the family law section and the low bonus section. President Tolleson referred to it, I think, as a brouhaha, and I said, no, it wasn't. It was two sections approaching a bill with a different perspective. And then they talked to each other about those perspectives and figured out a way to provide the legislature with information that it needed. nobody had to cave, nobody had to lose. But I would guess that both sides had their eyes opened a little more by hearing a perspective that they hadn't thought of. And that is exactly what we need to do. That's exactly why the people at the table need to increase, not decrease. The influence needs to be greater, not lesser. But the input, all of this input is still needed in the legislature. And just not to be a squeaky wheel, but that doesn't make it political. It makes it informative.
Thanks very much for that. Ellie Baxter has got her hand up. Hello and welcome back.
Hi, I'd like to comment on a couple of points discussed before. There were discussions by comparing other states' bars, like New York, California, Florida, and so forth. And I recently spoke with one of our executive committee members, International Practice Action, who resides in Florida. So currently our executive committee members are discussing whether to maintain our website, our own website, which is separate from the WSBA's section webpage. And we compared our website and the website of the International Law section of the Florida Bar. So the Florida International Law section's website is very sophisticated, professional, well-maintained, and we can see that there are many law firm sponsors. There are many logos of them. And what that EC member told me is that Florida International Law section has more members, more money, and they do more activities. And on the other hand, WSBA's International Practice Section EC members are currently discussing whether to keep a website or shut it down and go with the section's webpage only under the Washington State Bar Associations, because we are volunteers and it's been a challenge to maintain our website. And that's what we are discussing after we've been maintaining a website for about 9 years. So that is another example of how the WSBA is important for our section. So we do need the WSBA support for our activities. And also, Mr. Placci mentioned potential administrative impacts affected by this bar structure discussion. And I believe it was past president asking sections if we should charge about a $400 mandatory bar membership fee plus additional $400 for non-mandatory fee, as they do in North Carolina. Well, I have a North Carolina law license, not in right now I'm inactive. And I remember paying a little less than $400 when I was active. So obviously I was not a member of any of those optional membership. So I'd appreciate it if you could tell us what those duplicate work happening to the WSBA staff. The answer doesn't need to be provided to us right now, but maybe at the section leaders meeting next Wednesday, and that'd be wonderful. And I lived there in North Carolina for years, and I went to the University of North Carolina at Chapel Hill School of Law, and I could be wrong, but I don't recall there's any similar international law community there. North Carolina is very different from Washington. So we can certainly learn from other state bars, but I think we should always come back and refocus on Washington and rethink what's the best structure for us. Thank you.
Thank you. See, you've got any other hands up? Anybody else have any oh, Professor Straight?
Just very briefly, I have testified many, many times, sometimes at the request of the Law and Justice Committee, sometimes on behalf of the section as the section spokesperson. I have never had a problem in distinguishing our role when I appear on behalf of the section. That's what I begin with, and that's what I end with. And I suspect there was something else going on in the example being cited, and I certainly don't think that's a good reason to limit the voices of the sections. And I share Nancy's comments that the more the merrier in terms of perspective, and the idea that one of the reasons we have the sections is because the sophistication of our law practice nowadays and our knowledge of the law is so specialized, more than many of us would like, but it is. And not a surprise that there might be different perspectives. I know that there have been disagreements over legislation between the family law section and the criminal law section on occasion, particularly involving juveniles. And more power to the bar for working out a joint position. But I don't think that's really the critical thing here. The critical thing here is getting as many opinions expressed about the consequences of legislation or a rule change or something like that to the appropriate authority. And I really don't see the problem that as being one of truth in labeling. I suspect that was a completely, it shouldn't come to as a shock to anyone that the legislature is political, and that a chair who's not happy with the position that was being asserted by one or both of the presentations before him chose that as an excuse. But I doubt very much, assuming that the appropriate disclaimers were made, that they didn't understand fully what was going on.
Thanks, Professor. Anybody else have any thoughts, comments, insight, concerns they want to share?
Mr. President?
Dr. Stevens.
Yeah, no, I just wanted to, I appreciated the last part of what Professor Straight mentioned, because when I even look at 12.2C and talks about you should not be involved in political issues, it's like, well, you know, anything going to the legislature, anything going to the legislature is by its own virtue political. Decisions are being made that are political decisions in a political chamber making decisions. So I hope we always keep that in context. But yeah, I just had to say that, because I said, well, what are you going to do? What do you do if you're engaging in either advancing or commenting or opposing legislation? And all three of those things should be things that we do.
Okay, I think that we might be up to very close to future agenda items. I don't know if anybody else has any questions, thoughts, or comments. We've had discussion and comments from the Board of Governors here. Not all of them. Some of our board members have not spoken up, but had a pretty good representation. Yes, please, Executive Director Nevitt.
All right, so I'd be happy to talk a little bit about future agenda items. So the next meeting is planned for May 21st, and this will follow the Board of Governors meeting on the 19th and the 20th, and all three meetings will be held in Spokane, Washington. And of course, there will also be an online component. That meeting is going to focus on a little bit of what Director Platsche was talking about, looking at different models of bar associations, hearing from other bar associations about their models, and also doing some financial modeling on the models. So that's what the next meeting is going to look like. We also have meetings planned for June, July, and August. And because we canceled the March meeting, we may be adding another meeting somewhere in the mix. You want to turn off your microphone? At the May meeting of the board, I will be bringing some revised agendas for the Board of Governors to look at, in part because we canceled the March meeting. So we've had to move a few things around. So I'll be making an attempt at reformatting and sort of moving around some of the topics and bringing that to the board in May for feedback. And I think, so a little bit to be determined what the June agenda will look like, but the July meeting is our second meeting that's devoted to a full day of public comment.
Great. Past President Shichetti.
Just a quick question for Executive Director Nevitt. One of the additional agenda items, will that include governance? I know that was important for Justice Mabson. And we made we had a talk with her and said that that would be good to add. So is that included?
Yes, that's one of the topics I'm going to try to add.
Thank you.
Governor Stevens, is that you on 690? No. Oh, okay.
Yes, yes, that is me.
Okay, so you wanted to add something, did you?
No.
Oh, okay. Just want to make sure nobody gets ignored. I want to make sure nobody gets ignored.
Okay.
What do we got? Anybody else got their hand up? I don't see anybody else with their hand up. Anybody else want to talk about future agendas? Anybody in the room? I put my glasses back on to see the room. I don't wear bifocals, so I have to take the glasses off to look close up and put the glasses on to look far away. I'm thinking maybe we're done for the day. Does anybody have that same feeling? Okay, well, it's 3:45. We're a little ahead of schedule, but unless somebody else has got something they'd like to add, I propose we adjourn for the day. Any objection? Not hearing any objections. Anybody got their hand up objecting? I want to thank everybody for being involved in this process. It's going to take a while, and there's a lot of information to digest and a lot of thoughts that we all need to work on moving forward. But this has been a great day, lots of good discussions, lots of great ideas, and I'm hopeful that we'll just keep moving forward in a positive fashion with more great ideas and more great discussion at our next meeting. In the meantime, thanks so much, and we're adjourned.